On November 13th, 2022, 4 University of Idaho students, Kaylee Consalves, Madison Mogan, Xana Kernodle, and Ethan Chapin, were brutally stabbed to death in their off-campus home in Moscow, Idaho. After an attack, one of the surviving roommates saw a man leaving the house, his face covered with a mask, but she was able to describe the intruder's bushy eyebrows to police. After weeks of investigation, police arrested a suspect, a 28-year-old Washington State University grad student with bushy eyebrows named Bryan Kohberger. Now, Idaho prosecutors want to bring in a photo of Kohberger from the morning after the murders to show the jury that they believe Kohberger is the murderer with the bushy eyebrows. But first, in the early hours of January 29th, 2022, a chilling discovery shattered the quiet town of Canton, Massachusetts. Boston police officer John O'Keefe was found lifeless outside another officer's home, his body bearing the cruel marks of a winter storm. The initial shock deepened as investigators turned their focus to his girlfriend, Karen Reed. Prosecutors allege that after a night of drinking, Reed had purposely struck O'Keefe with her SUV, leaving him to succumb to the elements. They charged her with murder. Reed's defense painted a starkly different picture. They suggested a sinister cover-up, implicating fellow officers in a plot to conceal the true circumstances of O'Keefe's death. The courtroom became a battleground of narratives, each side presenting conflicting evidence and theories. Outside the courthouse and on social media, another battleground, which divided the community. The trial's intensity culminated in a deadlocked jury last year, leading to a mistrial that only deepened the case's intrigue. As the retrial approaches this April, the stakes have never been higher. Both sides back in court today, arguing critical matters that will affect the approaching trial. Tonight, we bring in our case insiders and take a look at all the latest. Good evening and welcome to Closing Arguments. I'm Julia Janae, filling in for Vinnie Politan. Court TV was back today in Denham, Massachusetts, and what a day it was in Denham. This was a pre-retrial hearing in the case against an accused cop killer, Karen Reed. We've all been anxiously awaiting Reed's second trial. It's set to begin in less than 2 weeks. And then we heard her defense attorney, Alan Jackson, argue that he wants a delay, he wants a continuance in this case. And this request for a delay is connected to a federal appeal, where the defense is seeking to have the most serious charge against Karen Reed, that second-degree murder charge, dismissed. That appeal hinges on the fact that jurors from Reed's first trial have spoken out to the media, to defense attorneys, saying that they did reach verdicts of not guilty on 2 of the 3 charges, second-degree murder and leaving the scene of a crime. And this is against Reed. But before that mistrial was declared, they say they reached those decisions but didn't write it down on the verdict form. So there's a problem. And the question now is, will Karen Reed's retrial begin on April 1st, or will the defense get the trial judge to give them a delay? And Judge Beverly Cannoni heard arguments today and issued her ruling. Let's watch.
If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
all three indictments, correct? You're defending all 3.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, That's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice, and we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance.
Well, I'm not going to grant the motion, all right? We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches, and we'll take it from there, but we will start April 1st with impanelment.
The date isn't moving. That's the decision by Judge Beverly Cannoni when it comes to the retrial of Karen Reed, and she's saying it has to do with the jury and the jury selection process. We want to hear what our insiders have to say about this decision and how it's going to impact things going forward. What's going to happen if the federal judge does something in the middle of the Reed trial? Joining us now from Massachusetts, we have trial attorney Wayne Dennison, criminal defense attorney Joseph Krowski Jr., Karen Reed supporter Nick Rocco, and YouTube host Kevin Lenahan with us. Thank you all for being here, weighing in on this case, as you have all done so eloquently in the past. And I'm curious about today. Wayne, let me start with you. What happens if a federal judge does something after the fact? Or really, let's start with why there's this habeas case and why the defense thinks that the federal court will do something different than the highest courts in Massachusetts.
Well, the defense thinks that they have a shot here, but every court that's heard it so far has rejected it. The trial level court, the highest court in Massachusetts, the district court, the federal district court. And if the case were somehow to be upended because the First Circuit takes the appeal and decides that both of the count 1 and count 3 need to either be reconsidered or dismissed, it will materially affect the trial. But as Judge Cannoni said, it's going to take a while to pick a jury in this case. I don't know if it's going to take 3.5 weeks.
Now, Joseph, what do you think about the decision from the judge? Because if it comes down in the middle of jury selection, the defense has said it's going to put them in a tough spot because they may have done their jury selection differently. Can you break down how the court would handle a decision, especially if it is in favor of the defense?
So what Judge Cannoni did was very astute. Look, logistically, this is a challenge. The number of juries required from a relatively small county, Norfolk County, requires immense and enormous planning. She's going to have impanelment start, but she is not going to actually swear the jury in till they get a definitive response from the federal court. Now, the federal court's already scheduled a briefing schedule. Whether or not they grant oral argument will probably be known to all the parties within the next 2 to 3 weeks. But at least they can make productive use of this time and start the impalement process, which probably will take 2 to 3 weeks. And again, look, there's still some unfinished business with these pretrial motions. So I think both sides will make meaningful use out of the time. As it relates to strategically choosing jurors, they're all experienced. That's something they can certainly work around. The factual allegations in the case won't change at all.
Nick, what was your reaction to knowing that the defense isn't going to get those multiple weeks they want? Is that going to change anything for them?
I think they're going to be ready to go regardless. I'd have to agree. I think if they do start paneling the jury on April 1st, as long as the trial wouldn't start before the federal decision was out, I guess there really necessarily wouldn't be an issue with that. They're going into this and they're going to defend her on 3 charges. If they happen to only have to defend her on 1 charge, better for them. So their strategy might have to change a little bit. But ultimately, I think it's fair if you do start on April 1st, jury in, because it's going to take weeks. I mean, there's no way it's going to take a couple days for this to happen. They're going to go through probably over 1,000 people before they find their jury.
And Kevin, why do you think that is? Why is this assumption that it's going to be much longer than perhaps the first trial in picking a jury when we still have a lot of publicity? We had a lot of publicity before the beginning of the first trial.
Yeah, we had a lot before, but I think it's grown a lot, not only starting during the last trial. So I think the jurors that were impaneled at that point, maybe it wasn't as widely known, but then through that first trial, it really started to take off, and then it's just continued to grow since then. And I think the defense here is maybe kind of hoping, I think they're probably happy that the judge did this today, because some of what we got alluded to today about new information that the prosecution has through John's phone and through the chip-off data really start to seem like the defense needs a Hail Mary here. And so they need some kind of a technical escape here where perhaps if the feds do make a decision and that forces things to, off the rails a little bit here, and if the trial was already started, they need some kind of a technical decision to get out of here, because the evidence is just so overwhelming at this point.
Well, let's talk more about that hearing. You mentioned phones, but I'm going to talk about another phone that was at issue today. And it's really because there were two hearings going on. The first one had to do with Aiden Kearney, a.k.a. Turtle Boy, and the second one on Karen Reed. But the lines between the two seemed to get blurred there inside of the courthouse. The special prosecutor from Reed's case was arguing cell phone data from the controversial blogger would be relevant as to Reed, and they wanted it turned over. And then there was this awkward moment when Reed and her defense team entered the courtroom, interrupting those arguments.
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team.
This is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
which can be dealt with at a later time.
A little bit testy from that judge, the judge who was overseeing the case against Turtle Boy and his witness tampering witness harassment case. So let's listen to those arguments, though, about the case at hand. It's whether or not the photo data that is with Turtle Boy's phone and whether or not it can be turned over. And you saw there the two sitting together at the defense table. Let's listen to the arguments from Kearney's attorney.
The government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Kearney and consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications, and that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Kearney's phones. We're not concerned about what's in Mr. Kearney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of a commission of witness in the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt.
Let's bring back in our panel on this. And Wayne, I'm wondering how unusual it is for a prosecutor from one case to go to the prosecution or the judge in another case to get evidence that apparently the state already has. Am I understanding that correctly, that the data has already been turned over in some form or another to the government?
You don't see that kind of interrelation very often. This is, I think, a fairly unique situation, which the prosecutor, Mr. Brennan, thinks can be sorted out with evidentiary rulings in the Karen Reed case. I suspect that that's the way it's going to resolve.
And Joseph, talk about this witness intimidation in terms of the text, because if they get turned over, would the Commonwealth be limited to only use texts that show harassment, or if they find something else they think is objectionable, could they use that?
Well, look, the basis to get access to the phone was allegations of witness intimidation, making the connection to consciousness of guilt. But certainly, if they get into the phones lawfully, anything they find in there that is evidentiary relevant and admissible and doesn't violate any privilege is arguably admissible at the trial against Karen Reed. Just to answer your question about it, it is certainly unusual, but I think because Assistant District Attorney, Special Assistant District Attorney Brennan is a special, this was a way to do it, an exercise of abundance of caution to actually get the endorsement from the court to get access to the phone, even though it's already in possession of the district attorney's office.
Nick, we see the video of the two. I think there's a lot of scrutiny now of their relationship between Kearney and Reed. What can you tell us about their relationship? How close are they?
I mean, I have no idea how close they are. I mean, it's pretty known that they've talked, they've communicated, which again is not a crime. I don't think Karen Reed has told Turtle Boy specifically to go and intimidate or harass witnesses. I know Kevin has said before, I know all about this, and I've seen this. I have never seen screenshots of anything. I've heard talk, but again, unless there's proof of it, it's never happened. So they have his cell phones. I'm sure they've looked through them already. They already came back with a no true bill. So I don't understand what they think they're going to find in the future of this. So.
And I want to talk about this documentary because it came up today. The special prosecutor mentioned the documentary for investigation discovery that Karen Reed participated in. So it's a series called A Body in the Snow, the trial of Karen Reed. And it's been the subject of arguments. It was 2 days ago being talked about because Prosecutor Brennan said that he learned things he never knew before based on what Karen Reed said in this series. And today he brought up that there's proof in this series that there were communications with Turtle Boy. Take a listen.
I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary.
Now, I wanted to see the clip, Kevin. I've seen parts of the series. I have not seen the entire thing. I think it's up to 5 parts now. Didn't notice what he's referencing. I'm wondering if you've seen it. Maybe some other members of our panel have seen this, and whether or not you think that it is something that could be used by the prosecution.
Yeah, I'm not sure which clip that he's referencing. I do know what Nick was talking about earlier was if you go back to the start of the trial, early May, at that time, and Nick can speak directly to this, and the admin chats from the Turtle Boy Facebook group, which Nick was and his wife are administrators of, showed that Turtle Boy himself was saying that he had information that he was threatening to take to the state police, showing that Karen helped him coordinate his targeting of the witnesses. Now, we don't know if he was making that up, if it was just bluster. He was upset at the time because Karen wasn't inviting him to sit in court. She had Nick take his place. So he was upset about this. So he was making this claim. Now, whether or not that information is actually on his phone, I don't know. But Turtle Boy himself said it was, and Nick can speak to that. He knows that's to be the case. He was there for those conversations.
Nick, we've only got about 15 seconds before break. If you want to respond, you can.
Words are words. I mean, there's no proof of it. There is zero proof of any of it. So I could say the sky's green. Do you believe me, Kevin? I mean, it's as simple as that. So we'll see what happens.
All right, our insiders are going to stay with us, so everyone stand by. When we come back, there were decisions made today about the experts who were really important in the first trial. Here's what Judge Cannoni said about that, but also here's a look at what's coming up in the next hour on Vinnie Politan Investigates. Tonight on Vinnie Politan Investigates, Lori Vallow Daybell has already been convicted of murdering her 2 children, Tylee and JJ, and conspiring to murder her 5th husband's first wife, Tammy, in Idaho. Now she's representing herself in Arizona for the murder of her 4th husband. So what really happened to Charles Vallow? We investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central, only on Court TV.
You feel that? The NWSL is on ION. It's game time.
Showing off a little skill now. Kansas!
The new Saturday Night Out is on ION all season long. Find ION wherever you watch.
ION, it's on.
Pumpkin.care.
I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate. I find that there is a flagrant violation of the Rule 14 obligations. Commonwealth, I am denying your motion to exclude the ARCCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations.
In case you don't remember all of the witnesses in Karen Read's first trial, the defense presented 2 compelling standout witnesses. They were accident reconstructionist experts from a group known by the acronym ARCCA. And notably, the 2 testified that John O'Keefe's injuries were not consistent with a vehicle accident. And during that trial, the real strength of these experts, so those of us who are analyzing this case, is that they were unpaid by either party, so seemingly unbiased. But on Tuesday this week, we heard Judge Cannoni. She determined a post-trial invoice from the ARCCA team to the defense, Karen Read's defense, proves that they deliberately misled the court. And even though they got a reprimand from the bench, Karen Read is going to keep her attorneys, and the experts can still testify at trial. So here's where we are now. The defense now wants to make sure that the new jury knows that there's evidence that these experts are unbiased based on who hired them first, reportedly the federal government. So does this matter? Who does it help? Let's take a look back at today's hearing.
The problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCCA, the jury's left to speculate about how they became involved, and it all inures to my client's, to prejudice my client.
We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCCA and what, if any, impact the defense had on ARCCA witnesses at the time they did the investigation. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair.
Still with us in Massachusetts, the Karen Read Insiders panel. We have trial attorney Wayne Dennison, criminal defense attorney Joseph Krowski Jr., Karen Read supporter Nick Rocco, and YouTuber Kevin Lenahan. Wayne, I'm going to start with you. Why would the government not want the information out in front of this jury that the federal government is the one who hired these 2 witnesses that were so strong for the defense?
It would ultimately invest these witnesses with additional credibility. that these people were hired by someone other than the defense team to make some judgments. They came to those judgments, and there will be blistering cross-examination as to the ultimate fact that they were paid, that they were coordinating with the defense in some respects. And out of an abundance of fairness, the defense team wants to be able to say, hey, we didn't hire them in the first instance. The federal government did, the DOJ did, or the U.S. Attorney's Office did, and they are in fact neutral.
Neutral. Joseph, do you believe that they are neutral? Because they're arguing that the federal government hired them and that's when they did their report, and any of the other stuff happened after they were done with their report. But apparently there were jurors from the first trial that thought that these experts were defense paid, that they might have been with Karen Reed's insurance.
Well, they certainly seem to have a relationship with the defense team that existed prior to the time of the trial. The problem for the defense here is they're not arguing a position for the strength from a position of strength. They can no longer really assert that these are truly independent experts. They collaborated with the defense team. They had phone calls that involved trial preparation. And shortly after the trial, they were actually paid $23,000 for not just expenses, but also for their time that included trial testimony and preparation. And it seems, for whatever reason, that was withheld from the court up until more recently in March of 2025. I have said before, trials are really difficult on defendants the second go around. And what it was a perceived strength for the defense at the first trial was these ARCCA experts, and a perceived weakness for the Commonwealth was Trooper Paul. Now, all of a sudden, it's been flipped, hasn't it? There's this cloud of gray hanging over these ARCCA experts. They've been named the crash daddies. Well, they've crashed. And now, all of a sudden, the Commonwealth has been able to retool. And we heard today, they've brought in a biomechanical engineer, Dr. Welcher, that it appears has gone above and beyond the actual work that the ARCCA experts did. Very difficult for a defendant on trial 2. The shock and awe of trial 1 and the element of surprise is essentially muted.
I agree with you there. Trial 2 is certainly going to be different than trial 1. Nick, can you speak to that cloud over the ARCCA experts? You, of course, are tapped into the Karen Reed supporters. How did they feel when we've gotten this information that has shown more of a connection between the defense and the ARCCA experts?
Well, the truth is the truth, and that's what should be put in front of the jury, which they were hired by the FBI. They came to their opinion before they spoke to the defense team. If the Department of Justice hired them independently from the defense and the Commonwealth, that's the truth. That's not a lie. If they received a bill for their time and their preparation, which their trial prep was not done with the defense team, their trial prep was done at their own home so they could prepare themselves for trial. So there's no reason why the jury shouldn't know that. Will it make them more credible? Yes. Does the Free Karen Reed supporters think that there's something sketchy going on with them? No, because Hank Brennan is trying to make it seem like that these two guys right here were in cahoots with the defense team. He also says that the defense team was in cahoots with the DOJ. So it's silly at this point. Let them testify. They want to bring him in for another voir dire. You know, I'm sure the defense team doesn't want to pay for it, but they're not scared of it. Hank can have 2 shots at them. He can have a voir dire and he can have his cross-examination. They're not going to crack under pressure. They're going to tell the truth.
Kevin, are we making it bigger than we should in terms of what the jury thought about the ARCCA experts? Have we heard anything from jurors who have come forward about the weight of the ARCCA experts on their deliberations?
There was some confusion on the part of the jurors as to who hired the ARCCA, so I can understand at an intellectual level what the defense complaint is. But the problem is if you're going to tell the jury that the U.S. Attorney's Office and the FBI investigated this investigation, that tends to create reasonable doubt, even though there isn't any. And like Nick said, the truth is the truth, but then you ought to be able to tell the jury the whole truth, which is that the feds didn't find anything that was exculpatory to Karen Reed and that the investigation is over. But I don't know how you introduce that. So the easiest way maybe just to stay the course and say, let's not talk about who hired the ARCCA guys. And just lastly, the idea of the U.S. Attorney's Office being automatically neutral. There is so much circumstantial evidence here, and Hank Brennan has hinted at it, that they were not neutral. Their relationship with Karen's team was described as Hank Brennan as murky, and he said that we still don't understand the true relationship between those two. So there's a lot of reasons to be suspicious that the U.S. Attorney's Office at the time, there's been a change in administration, was putting its thumb on the scale for Karen Reed. We don't know why.
Well, they got that flagrant violation from the judge for sure on this, but no punishment in terms of how things are going to move forward from the trial. Let's talk about another issue that came up today, and that had to do with an expert. We're talking about the whole truth and the whole truth coming out. There's a question of perhaps how much truth is going to be coming out, and is it too much? So we saw arguments get heated at the end of the hearing, and this was over whether or not the defense should be able to call an expert, Michael Easter, who's with the FBI. And what they want him to come in and talk about is investigative techniques, which could possibly criticize how the investigation was done by the Canton Police Department and the Massachusetts State Police. Take a listen.
What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony.
You wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Oh, no. Mr. Brennan said, what if I called a Massachusetts State Police officer to say that this was the best investigation ever? I have 2 words. Do it. Do it. I'd love that. I'd love a shot at that.
Wayne, is an expert going too far? Can't they handle that in cross-examination?
I've actually had a trial where we had a witness that was a police investigator who wanted to come in and talk about the fact that this was an investigation that didn't proceed according to standard practice. I doubt that this is going to come in, and this is a little too far. But I do believe that Mr. Jackson would definitely like an opportunity to cross-examine another state policeman as to how well this particular investigation went.
Joseph Krowski, I have to give you the last word because we're running out of time, but they have Michael Proctor and all of his issues. They're going to be able to bring that up, especially if he's on the stand, if not in the state case, in the defense case. So do they really need this expert to talk about the investigation?
So typically in a criminal case, this type of expert is used for pretrial consultation and trial preparation. The concern in a criminal case is that this type of opinion is going to invade the fact-finding province of the jury. So it's a rare circumstance with this type of opinion is actually allowed in a criminal trial. You actually see it more in a civil trial type setting. So I'm sure they've already got one. I'm sure they're consulting with him. Well, I know they've named him, but I really doubt that he's going to be allowed to testify. And if he is, there's going to be some really strict confined parameters set by the court.
There are still so many loose ends in this case, but it is still marching towards that April 1st trial date. Our thanks to our Massachusetts insiders for joining us tonight. Wayne Dennison, Joseph Krowski Jr., Nick Rocco, and Kevin Lenahan. Thank you so much for lending us your time. We are going to come back after this with the latest on another case, the new filings in the case against accused quadruple murderer Bryan Kohberger. Stay with us.
911 location of your emergency.
Something is happening. Something's happening in our house. We don't know what.
What is the address of the emergency?
1122.
What is the rest of the address?
Oh, Kings Road.
And tell me exactly what's going on.
One of the roommates has passed out, and she was drunk last night, and she not wake me up.
Okay.
Oh, and they saw some man in their house last night.
That heartbreaking audio was just part of a newly released 911 call that sparked the investigation into the 4 University of Idaho students, the ones who were found brutally stabbed to death back in November of 2022. And the accused killer is Bryan Kohberger, a grad student who lived not too far away from their off-campus apartment. He has pleaded not guilty. He's set to go to trial in August. And if he's found guilty right now, he's facing the death penalty in this case. And today we've received some new court documents in the case against Kohberger. And here to break down the latest from those filings and some of the bombshells in them, our Court TV field reporter Cody Thomas is here in studio. Cody, it's good to see you. Let's talk about this, especially this Amazon search. It's really revealing a lot.
Yeah, Julia, the state has actually now obtained a search warrant for Bryan Kohberger's Amazon click history, as they call it, pretty much all his history and things that he's bought, because they claim, the state, that they have evidence that shows that between March 20th and March 30th of 2022, remember that is a couple months before the murders happened that November, he purchased a knife just like this one, a K-bar knife. You see, it's big, it's hefty, a long blade on it, and again, this up here, this little strap, that's where prosecutors say the DNA that they found was located from his, that pretty much puts him in the house that night of those.
Because the sheath was left behind.
The sheath was left behind, exactly. And now, the defense also asked the judge to exclude any of this Amazon data because they say the state is, quote, cherry picking some of the purchases, more so to kind of fit the narrative that this guy is the suspect. Now, of course, with any defense motion, the state has a response. So the state said, in part, quote, without any legal basis, the defendant claims the state cherry-picked specific clicks or purchases out of the Amazon click history. This is simply not true unless you consider seeking only items of evidentiary value cherry-picking. The defendant fails to show how this evidence is unfair, confusing, misleading, would cause delay, waste time, or would be cumulative. That is because it's none of those things. And all of this to say, Julia, the state pretty much asked that the judge rule that this Amazon data is relevant and admissible. And the defense also says that account that they pulled some of this evidence from is shared between Kohberger and his family members.
So trying to say we're not 100% sure that he's the one who made this purchase, perhaps. But it gets pretty specific, I'm assuming, and is it just a general knife that we know about, or does it actually say the same thing that we see in the search warrant for this knife?
It's absolutely the same exact K-bar knife, the same exact one, not just a big knife, not just a hunting knife, the K-bar knife with the United States Marine Corps logo on the sheath, and he also purchased a sharpener to go along with it.
Let's talk about
to the state.
Bushy eyebrows. That was another subject of a new filing that was released. Tell me about that.
So, of course, we know that bushy eyebrow description comes from the surviving roommate, Dylan Mortensen, who was on that second floor, the same floor as Xana Kernodle and Ethan Chapin. She claims that night that everything supposedly, allegedly, happened, that she saw an intruder walk by her door, covered right about up to here, halfway his face, and she saw bushy eyebrows on this intruder. Now, the defense says that they want this evidence excluded because Dylan had been out drinking and partying as any college student would. So they said that her description might not be as credible or reliable as it could be. Now, the state says it's perfectly credible. That is what she saw, that's what she says, and she's more than competent to testify to that statement. Now, the key here, though, is, Julia, that if the judge signs off and approves this in the state's favor, the state says they will bring in a new picture of Bryan Kohberger from November 13th, 2022. That is the day of the murders at 10:31 a.m., so a few hours after the murders. And you can see the picture, the selfie that Bryan Kohberger, that they pulled from his phone from that same day. And the state says it'll be up to a jury to decide if it's factual that he actually has bushy eyebrows or not.
And for Dylan, I don't see why that would be excluded, because the defense could cross-examine her about her state of mind, whether she was inebriated, but doesn't mean that something that comes out as it's happening shouldn't come in. And that brings me to the 911 call, because they've had some issues with whether or not that comes in, and Dylan is the one on that 911 call. Is that true?
Well, Dylan among a lot of other people too, because it was a few hours later that 911 call was made, and they had some friends over. In the 911 call, you can hear multiple people passing the phone around. Now, the defense wants that 911 call to not be brought into the trial because they're claiming that it's hearsay. Now, the state says that the 911 call, statements made in that 911 call, fall within the excited utterances exception. Now, the defense says not so much because, again, that call came in hours later. But Julia, at the beginning of this, we played a small portion of the beginning of that 911 call, and what I want to do now is allow the viewers to hear the rest of that 911 call to really get a feel of the atmosphere in that house when those bodies were found that morning. Let's take a listen.
And tell me exactly what's going on.
One of the roommates has passed out, and she was drunk last night, and she's not waking up.
Okay.
Oh, and they saw some man in their house last night. Yeah.
And are you with the patient? Okay, I need someone to keep the phone, stop passing it around.
Can I just tell you what happened pretty much?
What is going on currently? Is someone passed out right now?
I don't really know, but pretty much at 4 a.m.
Okay, I need to know what's going on right now if someone is passed out. Can you find that out?
Yeah, I'll come. Come on, Bethany, we gotta go check. No, we have to. She's so sad. What's wrong? She's not waking up.
Okay, one moment. I'm getting help started that way.
Okay, thank you.
Now, of course, Julia, all of these motions that were brought up in this new dump of documents, they have not been ruled on by a judge yet. They're all still pretrial motions before that trial that's scheduled for August, but the judge has scheduled a hearing on April 9th to consider all of these pretrial motions.
Cody Thomas, thank you for bringing us the very latest. We do have to get to a break, but when we come back, we're going to reveal something else you need to know. Plus, coming up in the next hour on Vinnie Politan Investigates. Tonight on Vinnie Politan Investigates, after being convicted in Idaho for 3 murders, Lori Vallow Daybell is taking over as her own attorney in Arizona, where she's accused of conspiring with her brother Alex Cox to murder her 4th husband. Will Lori Vallow Daybell call herself to the witness stand? We investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
We believe the glove was his.
It was a setup.
They weren't fitting it.
If it doesn't fit, you must acquit.
Trial and Error. Why did OJ win? New episode Sunday night, 8 Eastern and Pacific, only on Court TV.
Welcome back. It's time now for us to reveal something else you need to know tonight. Today, accused child rapist and murderer Stephan Stearns made a rare appearance in a Florida courtroom. At the hearing, the attorneys argued over whether or not the public and the media should be allowed to attend his court proceedings before trial. His defense attorneys have requested that all pretrial proceedings in his sexual battery case be closed. He's got 2 cases pending. He's charged with murdering his girlfriend's 13-year-old daughter, Madeline Soto, in February of last year. And he's also charged with dozens of sex crimes related to images of Madeline found on his devices. Stearns' sexual battery case is set to begin May 5th. The murder trial scheduled for September of this year. Here's some of what Stearns' attorney argued this morning.
The media is, and likely will continue to dissect in every aspect of this case, from the public records request through discovery that was provided via the state through the public records forum, through any motion and every motion that defense files in this case. And so defense would argue there are no alternative measures that would, other than changing venue, that would preclude or allow for Mr. Stearns to have a fair trial.
Stearns has pleaded not guilty to all the charges against him. The judge stated today in a written ruling that he will make a decision on the issue within 10 days. And we'll, of course, bring you the latest there. Before we go tonight, there's a picture I need to show you. This is Brooklyn Hackathorn. Brooklyn is 17 years old and was last seen on March 11th in Youngstown, and she's missing. If you have any information on where Brooklyn is tonight, call the Youngstown Police Department in Ohio. The number's on your screen right now. You can always call 911 or 1-800-THE-LOST. The Youngstown Police Department, 330-747-7911. Let's see if we can get Brooklyn to a safe place tonight. That's all for closing arguments. We still have another hour of live true crime coming up next with Vinnie Politan Investigates. Stay with us.